start with you, Arthur. Your thoughts?
Well, let me just give you a little what happened yesterday, and I'll give you a little horse's mouth. So I was there. I was at the courthouse yesterday, and as you know, Megyn, I have a long-term relationship with Joe Tacopina. We went to high school together. We've been buddies. We had dinner the night before this whole thing went down. And Susan Nicholas and I have cases together. We know each other a long time. So they came out of the courthouse, and literally I was the first person they spoke to. And I asked them two questions. I said, what took so long? Because that was a long period of time to be in the courtroom. And they said it was the media, the media's attorney arguing for more access. They wanted photographs to be taken during the whole proceeding. They wanted video in the courtroom. So that was my first question. But my second question is, what's in the indictment? And Megyn, they were both Joe and Susan had these big smiles on their face. They're like, it's nothing. It's nothing. It's what we thought. They didn't use the term you used, which is an accurate term, stacking. They go, it's one crime that he turned into 34 crimes. And then Tacopina looks at me and he goes, Aidala, it's not a crime. There's no crime here. And I think our friend is going to be able to tell us that there's no election law violation here. At best, there may be some misdemeanors here. And if the judge says they didn't, in the grand jury minutes, did not satisfy that bootstrapping into the felony part of it, it's a possibility that either the whole case gets thrown out, which is going to be the first motion they file, or maybe there's misdemeanors left. But weak, as you and I said on Monday, this was weak. It turned out to be weak. I've looked at thousands of indictments in the city of New York, and this is a weak indictment. Period. Amen. And Alvin Bragg did himself no favors yesterday, as you said, doing story time with Alvin Bragg, as opposed to doing what Mr. Morgenthau would have done, the storied district attorney in Manhattan, which would have come out with guns blazing and basically would have done an opening statement to a jury at this press conference, showing you what a powerful case he has. That did not happen yesterday.
I think, Dave, you'll agree that if it's reduced to the misdemeanor of falsification of business records, this case is done. That the statute of limitations has run on that. The only way we're still having a court proceeding is by tying it to the alleged intent to cover up an underlying crime.
And Megyn, even if he's found guilty and the statute of limitations has not run of the misdemeanors, it would get a slap in the wrist. It would be a loss for the prosecutors. The only way they can move forward with this is if it's a felony. And when Arthur and I were on your show on Monday, I thought maybe there'd be some surprises. Remember, I said, perhaps there's some more serious financial crimes here. And you were very prescient because you said that my reliance on Jennifer Weisselberg, the ex-daughter-in-law of CFO Alan Weisselberg, was misplaced because although she may have testified before a grand jury, it was a different grand jury, and the prosecutors weren't going to rely on her. I thought that she was testifying for a reason and they would add more financial crimes. They didn't. This case is all about the hush money payments. And so, as Arthur said, you got to find the second crime that it leads to, that it conceals, or else you got nothing. So what is that second crime? Unfortunately, the district attorney's indictment does not tell us. We don't know. And he made a press conference afterwards where he suggested it was federal campaign finance violations. And that's why I'm glad we have Brad on the show. Also, you have state election law violations and possibly some tax fraud. Now, each one of those is problematic. When it comes to the federal campaign finance violations, you'd have to piggyback on federal law as a state prosecutor. That's uncharted territory. Number two, when it comes to state election law violations, that's a vague, broad statute that may or may not be preempted by federal law when it comes to federal races. And number three, when it comes to tax fraud, that could also be problematic because it looks like Michael Cohen paid the taxes. That's why he got such an excessive reimbursement for the money he laid out, and there would be no loss. Now, to me, this means that the greatest threat for prosecutors is this case getting dismissed in advance. If they could get this case to the jury, I think the facts and the statement of facts were more compelling than I thought they would be. I think they do show intent to influence an election, but I don't know if this case will get to the jury. That's the big question I have.
All right, and that leads me to Brad. So, I mean, I do think Andy McCarthy was saying yesterday, you can't do this. No matter what Bragg says about, the law doesn't require me to tell you what your underlying felony was. Because he's trying to keep his options open. Andy McCarthy was saying, no, this violates a defendant's Fifth Amendment right to have notice of the charges against him so he can adequately defend it. And also to prevent double jeopardy. Because what if we go through this whole trial, Alvin Bragg never commits himself to a theory, Trump gets off, and then somebody else tries to take a second bite at the apple, right? He wants to use the indictment to say, I've already been acquitted on this stuff. You can't try me again. This is my constitutional right. So we do need to know what the underlying alleged felony is, no matter what Bragg says, whether he thinks he's required to tell us or not. So as Dave points out, we've got federal election law, we've got state election law, we've got state tax law. That's what Bragg said are the three possibilities. So federal election law, you were the guy, Brad, who was responsible with figuring out whether somebody should be charged for violating this. Why? Well, you tell me whether it would potentially be a violation of federal election law for Trump to have sat down with David Pecker of the National Enquirer and Michael Cohen, Trump's fixer lawyer, and said, let's set up this scheme whereby, David Pecker, you either go find people who are going to trash Trump or you just remain open-minded when those people walk through your door. And we establish a fund and we pay those people to say, thank you so much. We'll take the exclusive rights to your story, and then you never publish them. Thanks. I appreciate it. You're a great man, David Pecker. Peace out, Trump. Is that a crime?
No. Now, let me begin by going to the state election crime, because I think this is all tied in. As we just heard the DA Bragg say, the state law is a state law that says it's unlawful to try to influence an election by an unlawful means. So he still needs an unlawful means even to get that state charge in. So you still got that piggybacking requirement. And that takes us to the federal election law, which is the only thing that appears to be claimed in the indictment. The federal statute says that a contribution or an expenditure is anything that is for, quote, the purpose of influencing a campaign. And this is what they've hinged everything on. And they say, well, look, that was his purpose was to influence the campaign, case closed. The problem is that's not quite the proper reading of that statute. The Supreme Court has long held, and this is a bedrock principle of federal campaign finance law, that you can't have vague standards that are subject to the interpretation of the listener or the subjective mindset of the person who's speaking or acting. So, for example, if I run an ad saying, they shouldn't indict Trump, they should indict Hunter Biden, right? Even though my purpose might be to help Trump win re-election, that's not an expenditure under the Federal Campaign Act. You have to say something like vote for, vote against, defeat, support, that type of thing. Similarly, if I give money to, say, a pro-MAGA think tank, thinking that this is a good way to help Trump win re-election. So my purpose is to help Trump win re-election, is to make a contribution. That's not going to count. It has to go to the campaign or to some other operation that is specifically advocating that election or defeat. So the subjective purpose of the spender is not really what's at issue here. We can play that out into other examples. Let's suppose I decide to run for Congress. And I say, I need to be in a debate and I need a really good suit. So I go out and I spend, $2,000 on a suit, which I would never otherwise do, right? It doesn't make it a campaign expense, even though my purpose was to do it to influence the election. Or suppose I'm an individual and I have a messy divorce in my background and I decide I'm going to run for office. And I say to my lawyer, can we seal those records? And I pay my lawyer to try to seal those divorce records. Even though I'm doing it for the purpose of influencing a campaign, it's not a campaign expenditure. And in fact, the federal law discusses this in detail with another part of the statute that says not only are these things not campaign expenditures, it is illegal to use campaign funds for these types of activities. Anything that might exist, whether you were running for office or not. You just can't spend the campaign funds on it. And I think that's a very practical observation. So that's where we begin. The mere fact that it was for the purpose of influencing the election in Trump's subjective mind or anybody else's isn't really the criteria that we use for determining if federally is for the purpose of an election. And of course, hold
that next thought. Let me just jump in. So if Bragg can prove the Pecker, Cohen, Trump meetings happened, the three of them got together and said, these women are a pain in the butt. So is that doorman. We need to pay them off, make them go away. I don't want this coming out before the people go to the polls. You say, as the former head of the FEC, that is not illegal. That's not illegal contribution to a campaign.
That's right. No more than if the four of us sitting here now said, let's hope that we could do everything we can to make this session help Trump get reelected, right? It still doesn't make us involved in a federal campaign expenditure.
I have never been able to compost before. Have you? It always seemed too complicated and like too much work. Not anymore, thanks to Lomi. Lomi allows me to turn my food scraps into dirt with a push of a button. Lomi is a fun countertop electric composter that turns scraps into dirt in under 4 hours. There's no smell when it runs, and it's super quiet. Thanks to Lomi, we have way less garbage in our house each week. Instead, we are turning our waste into nutrient-rich dirt that I can then feed to my plants. Now I am composting with the best of them, creating soil instead of waste. I have a basically limitless supply of dirt for my garden, which is fun because now that I live in the burbs, I have one. And if you want to start making a positive environmental impact or just make cleanup after dinner that much easier, Lomi is perfect for you. Head to lomi.com/MK and use the promo code MK to get $50 off your Lomi. That's $50 off when you head to lomi.com/MK and use that promo code MK at checkout. Food waste is gross. Lomi is your solution. Lomi.com/MK. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.